I'm very happy to introduce the next speaker, Carmen Saginario from Cape Hard, Scatcherd.
Thank you, Jerry. Welcome, everyone. I know this. I have a feeling that last night none of you slept. Kind of like Christmas Eve when you're really whipped up, you can't sleep because there's something riveting to happen the next day. So I'm sure you were so excited about the presentation on the 2% arbitration cap that you didn't sleep. So we're going to try to make it as exciting as possible, which you can imagine is not exciting at all. But I also have to take issue with Jerry, and I'll tell you why. He brings in Vince Papale, right, to give a speech on whatever Vince, I wasn't here, motivation, his past, where he sees his life, where it's going, and he brings me in to speak about interest arbitration. Really? There's like a ton of other things I could have spoken on, but here I go. So as Jerry indicated, Jerry brought me into Cumberland County because we had some successes elsewhere dealing with interest arbitration. But before I get into that, I want to do one thing, because Jerry's in Cumberland County have been very, very good to me. As a lawyer, what do you want to do to keep clients and to get them? A, you want to do really good work, but B, you want to do this, right? Sucking up is always good. So as we know, Jerry was sworn in this morning as president, so I wanted to say, Jerry, I'm sucking up. Congratulations. And if Jerry's not in the room, please everyone tell him that I had a big suck up in the beginning of my speech. So anyway, let's start. What I call is the pre-arbitration dance. And there is a process which most of you probably are aware of. Let me just ask this question. Who in the room has actually participated in a full interest arbitration in their career? How many people? Raise them. Probably 10, right? What's the reason? The reason is we really don't want to go there. It's kind of like, I hate to say it, a divorce, a separation, a contract dispute. You don't want to go there because you don't want someone to decide your fate. You want to try to decide that fate on your own through rigorous negotiations, okay, and through serious preparation, which we'll talk about. So what's the negotiations process? A lot of this is really common sense, but I'm hoping you take some advice from this. One, the negotiating team has to be decided upon. And that's a very careful decision in my experience. I'm sure you all work for governing bodies. And a lot of the governing bodies want to be involved in the negotiations process. It's certainly up to them because they're your bosses, but I will tell you, in the places that I work for over the last 25 years, I have always suggested and sometimes insisted that members of the governing body not be involved in the negotiations process. There's a couple reasons for that. One is to give them what I call plausible deniability, right? Let them deal with the issues after the negotiations meetings. If they're sitting at the table, they are going to want to make a comment. They're going to want to make a statement. These are political people. These are people that are elected. You in this room, I dare say, are not elected people. So my view would be we want to be very careful about having elected officials in any capacity in the room. I've represented several bodies over the last 15 years that they actually did not have their financial people involved in the negotiations process. I have to tell you, it blew my mind when I went to a particular municipality that I represent, and I asked the CFO, have you ever participated in the process before? He said no. Have you ever done a scattergram? Have you ever done a salary chart before? He said no, the payroll people do that. And I said, well, how did you determine whether or not you could properly budget for the salary increases? And his response was, well, they told me what the increases were. My payroll people costed them out. and I somehow figured out a way to do it within the budget. For me, like, again, that blew me away that the CFO was not involved. So if you are all in the financial world, my sense is interject your way in some way into the negotiations process. 3, HR people. It's not all about money. A lot of it is about HR, human resource issues, whether it's FMLA, whether it's, and this is one of my pet peeves, sick time being included in time worked for purposes of overtime, right? That's a big issue that at least I harp on all the time. I try to negotiate out of all of my contracts, and if I can't negotiate it out, I arbitrate it out. Number 3, who should talk and who shouldn't talk? It's one thing to have a group of people sitting at a negotiations table, all of whom know the organization a lot better than I do. I never profess to know an organization as well as the people on my negotiating team. But what I do try to do is to try to have one person be the lead negotiator. From my perspective, most of my clients prefer that I do that for a number of reasons. The message is consistent. I go back, I get input from staff, from the executive directors, from the business managers, from the township administrators, from the CFO. We caucus, we come back. I know what I'm talking about at that point because I've listened, and then we provide whatever our proposal or counter proposal is. But again, if you have 3 or 4 people talking at the table, it's going to be an inconsistent message. I represented a school board once where I had 2 school board members who insisted on being at the table, and they started negotiating salaries with teachers' aides. Like, did it undermine me? Absolutely. Did I care? Absolutely. Was it my ego? Absolutely not. It was about getting the best possible result for my client. Who should not talk? Okay? I'm going to say this to the guy I sucked up to. Jerry is one of the best CFOs in the state. I've worked with a lot of them. This guy knows what he's talking about, can do numbers in his head. Most of them are wrong. That's a whole different story.
Hey, they're
Okay?
numbers. You want a number?
But you know, we had a situation where, I'll just say this out loud, Jerry, in the last negotiation session with a bargaining unit down in Cumberland, he ticked them off. He ticked them off because he kept telling them the truth, and they didn't want to hear it. So when it got down to negotiations this time, they said behind the scenes, we really don't want Jerry to talk. And I said, you know what, Jerry's going to talk when we say Jerry can talk. But the point is that was actually said behind the scenes. We don't want Jerry to talk. And again, I know why they didn't want him to talk, because he told them the truth. And we're going to talk about some truths that I'm sure all of you know about. Finally, which as I said before, is don't go into a negotiation with an arbitration mindset. You don't want to go to arbitration unless you absolutely have to. Try to settle, be tough, but try to get the best deal you can without arbitration. So, like in any other thing that you do, I'm sure Vince Papali, when he gets in here to listen to my speech this afternoon, he is going to say what I say. There's no substitute for preparation, right? So what does that mean? What should we be doing? In the first instance, it makes some sense to get some general guidance from the governing body. You know, your clients, your constituents. Where do they want to go? Where is their head at? You don't want to get specific direction, but you want to get some general consensus, because ultimately, the MOA or the contract goes back to them for approval. Second thing is get some input from staff. Well before the contract is going to be negotiated, someone should be distributing the contract to key staff and say, in your experience, right, with this contract, you tell us what changes you want. Like, there are operational things in all of these contracts that people say, you know what, I'd like to change it, but it's been like that forever, right? Don't a lot of these contracts just roll over, and then you look at a provision and say, how the heck did that provision get in there? And as it turns out, that provision was negotiated during the Depression in 1929, and it never made it out of the contract. So get your key people, mandate that they look at the contracts and then have a meeting, an internal meeting with your negotiating team to decide what types of modifications you want. That's a really good preparatory exercise. And at that point, no one's surprised, and your staff can't say, you didn't tell me that you were going to engage in negotiations. You didn't ask for my input. All you did was go into a room and agree on a number. But I care about something different. I care about how they use sick leave. I care about after 3 days they have to give a note. Those are the things that people care about that we as, I'm going to say, management may not quite understand or know about. Seek the union proposal. If you can, try to get it up front. They usually don't want to give it to you, but it doesn't hurt to ask. And the way I ask is, look, I don't want to go into the first meeting and dance around and introduce each other. Of course, we pass around the sign-up sheet, which we really like, that nobody ever looks at again, right? And that takes 15 minutes, sign-up sheet thing. And before you know it, you've wasted almost a whole meeting. See you in the first meeting if you can make some progress. If you can get a proposal out of the union, first meeting, that would be awesome. Preparatory for the first meeting. Cost out your own proposal. Think about where you might want to go. If you want the guide, for example, if there's a guide involved, you want it to remain the same, right? Take the existing workforce, run a 3 or 4 year contract, depending on what you're thinking, and see what that does under the existing guide. And then finally, gather the relevant data. This is really important, and most people don't do it, but the ones that are most prepared are the ones that fare best in negotiations and in arbitration. I'm going to show you some relevant data that we've gathered in Cumberland County. One, comparison of rateable base. Right? Do we have any, let me see, Bergen County people here? Bergen, Bueller? Nothing? Okay, I was going to say congratulations, your rateable base is great. You're going to get killed in arbitration, but that's a whole different issue. I'm only kidding. But this is something that the arbitrators take into consideration. This is readily available online. 2, right? Tax information. Again, what's your average residential property value? These are things that your staff or some of your people that work with you, they can gather all this information preparatory to negotiations, and all of this information will be something that the arbitrator will consider. So it won't be a waste of your time if you gather this information. Now, this is something that is key. When we go through the factors that an interest arbitrator will consider, this is one of the key factors that an interest arbitrator considers, and they compare the proposals, and they compare what your particular units to units that do similar things, primarily in your geographical area, and also units in your own town, county. You see here, we had a proposed salary guide from a particular bargaining unit this year in Cumberland County. Jerry and others put together the comparisons that you see. We compared the corrections officers, we compared the sheriff. Then we went further. We went to the neighboring towns. We went to Millville, we went to Vineland, we went to Bridgeton. Then we went to South Jersey. These are the things that an interest arbitrator will look at, and these are the things that will give your team a negotiating advantage when they will always come to the table and say, we are the lowest paid police officers in Burlington County. And guess what? 99.9% of the times they're wrong or they're trying to bullcrap you, right? If you have these documents readily available, and that's what we do, we say, really? You really are? Okay, here. And you show it to them because this is all public data. It tends to rock them back, tends to want to make them settle because they think or they know that you're prepared. Finally, this might be really difficult to see, but this is something that Jerry and I have worked on many, many times. Maureen is here from Evesham. We work on the same format. We do it the same exact way, and I would encourage you to take a careful look at this. If you need, by the way, if you need or want any of the slides, please contact me directly. I'm willing to share anything with you folks that I have. What we do here is we take their proposal, the union's proposal, and we actually cost it out per person. Because people think, and I think most of you know this, well, we're only asking for a 2% raise. It's only a 2% raise. But I think we know better. Because when you look at the guide on the bottom of this slide, what happens? The guide increases by 2% every year, such that when Mr. let's say 72,000 person at step 8 on the left, on the top, he goes from 72,000 to 82,000. He doesn't go from 72,000 to 77, because what's happening on these guides is they are going horizontally on the guide. And this is something that I call percentage increases over and above step guide.
Carmen, could I jump in?
Sure, Jared.
So, let's give you a chance to breathe for a second, right? Carmen mentioned the movement up the guide or down the guide, and the impact that has. This guide, if you're fortunate enough to have eyes that can see that guide, but I'll tell you, this guide is what the arbitrator kept referring to as a static guide. We're in the mediation session with the arbitrator. You guys don't know how lucky you are. You have a static guide. Over 5 years, your guide doesn't move. So in terms of the, it's only 2%. Well, in our case, I guess it's a 0. The guide doesn't move at all, so therefore it's a 0. If you look at the totals at the bottom with the step progression, you got 3%, 2.3, 3%. The movement on the guide, depending upon how many people are on what given step and the value of that step and the value of that progression, the step movement itself is typically over 2%. And you need to deal with the people on the top and be very creative on how to get this down around or within 2%. We were very generous. We were looking for 2.9, but we were getting significant givebacks in the health benefits. We restructured the health benefits plan, and we're looking at sharing the costs with them, 1/3 for them, 2/3 for us, because we make the rules. So the arbitrator kept beating it. The arbitrator absolutely hated that the guide didn't change over the 5 years. Our opinion, our proposal, every time we negotiate the guide. We change the guide again when we negotiate again. We don't change it in between.
And I dare say that I've looked at interest arbitration awards over this year, which we'll talk about a little bit later. And actually, this is very similar to a proposal that was agreed to during an interest arbitration, because the arbitrator told us, you guys are getting concessions. As Jerry said, we stuck really firmly with what you see on the bottom, which is a static guide. When I say a static guide, it means the guide stays the same every year. That is unconventional. The unions hate it. I get stopped in Mount Laurel or Morristown in Cumberland County. I've gotten 3 tickets because they know who I am. The unions absolutely hate it. But when we lay out to them that even under our proposal, particularly the guys going up the guide, if you look at the very right-hand side, the people that aren't at the top are getting an average of 3.4, 3.4, 3.4, all the way up to 5%. Yeah. So I dare the unions, go to the public and tell the public that you are angry that you're getting 4.8% per year average increase.
They will tell you that this has never happened before. Then I found not only do we have a 5 or 6 year history past practice amongst all our unions for having static guide, but I was able to find several examples from other counties or from police forces. It's unusual, I give them that. It is very unusual on a PBA to have a static guide, but it's not we didn't create this.
And we did this, I think Maureen and I did it back in 2013 or something in Mount Laurel. We started it because we got to paying attention to saying, wait a minute, The governing body is saying 2% across the board, 2% across the board. It sells really nice in the newspapers, but if somebody were to drill down, the 2% really is average of 6%. It's ridiculous. Are you Mike Carino right there? That's my high school classmate, Mike Carino. Let's give him a hand right there. You look so familiar. I'm looking at you, and you're smiling. I didn't like the wink, though, Garino. It was a little bit different. And by the way, I played second-string quarterback in high school, and he was my center. So we are very close, if you know what I mean. Not that there's anything wrong with that. So anyway, the guide is really important. And it's really important to cost out their proposal, and it's really important to cost out your proposal so you can actually speak in an educated way to the people who are going to be reviewing this. So the governing body can speak in an educated way to the public who may be asking them questions about what is this 2% across the board business. And that's why we spent so much time on this. And I say, don't be fooled by the guide, which is kind of the lesson, which is 2% across the board. I hate those words because I know what it means. It means 6, 7, 8% increases for people that are already making a good living. When, by the way, most of you are at the level that you're at, you're getting 1.75. You're getting 1.9. You're getting 2, right? The people in the bargaining units are getting way more than that. So now we've negotiated, we've done the dance, we have all the relevant data, we think we're great, and the union says, you know what? There's no more 2% cap, right? And we've gone to all these sessions where the union lawyers speak, and the cops get up, and the firefighters get up, and they say this. It's the Wild West again. We're back in 6 to 8% raise territory. We've gotten cheated on this damn Chapter 78 all these years, and here's what we're going to do. We're going to make our money back. We need to make the money back that we were cheated out of by the 2% cap and by Chapter 78, which not one person in this room, by the way, had anything to do with.
Carmen.
Yes, Jerry.
So, Carmen's an attorney. He's got to cite his source. They actually had a conference where they rallied around this and then published it in a police magazine. They're pumped up. They're doing training sessions on how to get our taxpayers' money.
And again, what's happening really is the bargaining units are buying into it. Because all they're hearing is Chapter 78, which I'm sure all of you know what that is, obviously. It's now negotiable, right? So we can negotiate anything we want in Chapter 78 as long as it doesn't go below the 1.5%.
Salary, yeah.
And the 2% cap is no longer in place. So here we go. It's the Wild, Wild West. And the bargaining units are buying into it. They're walking into the rooms with their chest pumped high, and they're saying, no way, no how, we're going for your static guide, or no way, no how, we're going for any small monetary increases.
Fortunately, I was a college wrestler. I enjoy this.
Jerry
It's
loves
fun.
it. Jerry's favorite 4 words are "let's go to arbitration." But anyway, so the options, right? Now you have an impasse, but you do have some options. We just filed for our interest arbitration, one of my clients, and our goal was, let's get their attention. We have a really good proposal on the table. They came back with something that we believe is outrageous. So we filed for interest arbitration. But what we're going to do is go to mediation. Because what we're hoping is that when an objective third party comes in, and we show the objective third party that, hey, we're giving these guys a 3.5% per year aggregate increase, the arbitrator is going to say to the bargaining unit, are you guys crazy? Take it and run.
You're going to lose.
And it may give us the cover, may give them the cover they need. And the same thing with us, by the way. You know, we don't always have the most reasonable approaches, but if a mediator or an arbitrator, in the case of Cumberland, said to us, guys, they're making so many concessions, you're getting a static guide, take it and run, that helps us with our governing body, helps us with our clients. So I would suggest, unless there's no way, no how, go to mediation first, then arbitration. If you go to mediation first, the 90-day window doesn't start. But once that 90-day window starts, man, it is crunch time.
Yeah, in our case, the PBAs refused mediation, and the arbitrator came in and insisted on mediation.
But the 90 days was still running. So as we were mediating, we're looking at the clock thinking, we got a lot of work to do in the meantime if we don't resolve this thing. It used to be called the rocket docket. Does anybody remember that? The one arbitration I did, which we'll talk a little bit about, it was a 45-day rocket docket. So arbitrator Susan Osborne called us in. She said, here's the ground rules. We're having an arbitration on November 15th, and I will have a decision by November 26th, which she did. It was crazy. I didn't sleep for 2 months. So what does an interest arbitrator consider? This is kind of where it gets really, really exciting. This is awesome. First of all, I'm not going to read all this stuff. You can all read, right? But again, there are certain things that the arbitrator has to be. He or she has to be, A, it's not on here, honest and not on the take. Okay? We need to have that. 2, reasonable. And they have to look at all the factors that we're going to talk about, and they have to determine which factors are relevant and which factors aren't relevant. And if you see the second bullet, they actually have to list which factors are deemed relevant and why these are deemed relevant and why the others are not. Several years ago, we had an arbitrator, and I'm going to say his name was Harris because it's public knowledge. He issued an arbitration award in Burlington County for the prosecutors, detectives, and he didn't do that. And his arbitration award was outrageous anyway, but that's a whole other story. I was able to get the arbitration award overturned simply because this gentleman did not, you're not Mr. Harris, right? I'm only kidding. Simply because the arbitrator didn't list what factors were relevant and which ones weren't. In the final analysis, this stinks. 6 months later, he just rewrote his opinion, made a list, relevant, not relevant, this is why, and we did not fare very well. But the point is they have to do that. These are the factors: interest and welfare of the public. This largely rests on the tax levy. It largely rests on basically general criteria that the arbitrator wants to consider. And it gives them a little bit of a free rein to kind of fly a little fast and loose with the general interest and welfare of the public. We talked about the comparison of the wages. Again, those are things that you need to have data for up front. The extent you're more prepared, the better. Overall compensation presently received by the employees. This is an interesting one because, as you'll see in a subsequent slide, the overall compensation actually does include other stuff that the employees get. It includes clothing allowance. It includes pension contributions. It includes other paid leave. It includes sick time buyback. It includes all the things that we know that cost us money that really doesn't show in our salary number. And then stipulations of the parties. If you go to interest arbitration, to the extent you can stipulate to certain things, it certainly shortcuts the process. I will tell you that by the time you get to interest arbitration, the parties usually hate each other and you're not talking, so you're not going to stipulate too much. They also consider the lawful authority of the employer. As I said, the 2% tax levy, which is related to the interest of the public, which is number one. The financial impact on the governing unit. The cost of living. Again, we can get this in 5 seconds off of a Department of Labor website, but they look at that because the cost of living, and it fluctuates, let's say, between 1.2 and 2.3%, and the unions are seeking 6%. That's relevant because no one else that's getting cost of living increases is getting a 6% increase. They're probably getting, as I said, between 1.2 and 2.6, whatever the number is. Continuity and stability of employment. This is a great one. This is a great one. We hear this all the time. We can actually, it's like a broken record. If you don't give us this raise, what's going to happen? Everybody's going to quit. And guess what we have before that's even said? We have a list of everybody, and we show them in the last 10 years, This is how many people have left the department.
I'll top that. We have employees that live in other counties and working for us, and they're threatening us to go work for other counties. If you could, you'd already be there.
And sometimes I get frustrated because I tend to be a little hot-headed, and I want to say, then go. Then go. Because you've been here for 13 years. You're at the top of the guide. You're making $109,000, okay? If you think you can get more somewhere else, God bless you. But generally, it's not happening, right? But I almost want to say go, but I think that's not in the best interest of my client.
Yeah, I'll say it for you.
That's why we don't let Jerry talk. Anyway, and then the statutory restrictions imposed on the employer, again, those are things that mostly relate to finances, which are all kind of put in the same financial bucket, if you will. We talked about this earlier. I'm going to kind of blow through it quickly. How do you get the comparison of the wages? Right? It's not that easy. I mean, there are some Department of Labor statistical sheets that you can access. But what I do is, when I get involved with a town or a county, we have a librarian who's awesome. I have her do Oprah requests. Do any of you field Oprah requests here? It's a killer, right? Right? But I represent places that all we do is field Oprah requests. So I'm figuring if I have to field them, I'm going to use them. That's a good way to get information. PERC is supposed to have all of the agreements and settlements on file. I dare say they probably have 10% of the settlements on file, but you can try to access PERC as well. Yes, Chair?
Much easier. I don't like Oprah. I hate Oprah. I do like my fellow CFOs. So we typically, everyone in this room, we're all friends, call each other. Hey, I'm going through a contract negotiation. Yeah, send me a PDF of your contract. Within an hour, I had most of the data I needed from my local municipalities and my surrounding counties and wherever else I needed it. We all will go through this. So someone calls you, I need this, you give it to them because next year you're going to need it. So we could do this without Oprah. But if we are not successful, then we got to do that four-letter word.
And when you say you hate Oprah, you're not talking about Oprah, right, Jared?
I plead the fifth.
All right. Overall compensation, as I alluded to earlier, it includes these other things. But what's interesting, but they're not included really in anything else. When the arbitrators look at the gross aggregate salary for the units in any given year, all the stuff that's on that list is not included. I think what they do is, I know what they do, is they include that in the overall comparison to how your unit members are paid, particularly with respect to people that do the same job in the geographical area. So they do look at the overall kind of package that you provide. For example, if any of you have taken steps to lessen the Chapter 78 contributions, right, an arbitrator would probably take that into consideration because now people have what? They have more money in their pay. It's like giving them a raise. You lower it from 35% to 25, whatever it is. Now they're taking home more money. Financial impact, we went through this earlier. This is something, again, that is, especially for folks in your position, extremely important. Now, this factor is critical. The parties shall introduce evidence regarding the financial impact, and the arbitrator has to analyze and consider the factors set forth in the same paragraph. So this is not one that the arbitrator can say, oh, by the way, I really don't think it's relevant because these guys live in Hunterdon County and it's a relatively affluent county, so they can afford pretty much whatever we award. The arbitrator has to go through that process and has to do it relatively thoroughly. They have to take into account how the award will affect the municipal or county purposes of the local property tax. They have to do that. Like, they have to know what they're doing. Another one, they have to compare the percentage of the municipal or county purposes element required to fund the contract with the preceding local budget year with the current local budget year. So they have to get in there and look at your budget. But what that also does is it puts the onus on us as public servants to put that information before them and basically say, it's going up, we can't afford it. Impact of the award for each income sector, then the impact of the award on the ability of the governing body to do certain things. This is something that is oftentimes overlooked. Because again, as I'm going to say, as financial folks, we pretty much pay attention to the numbers, right? That's what we do. We have to have a balanced budget. We have to have our audits done. We have to do the things that we do, and we do them well. But what needs to be addressed is, how does an award that's exorbitant affect other things? So this is where other departments come in. If the police get an award of 6%, if that happens, what do we have to do in terms of our budget? Who are we going to take that away from, right? Who are we going to take that away from? If the fire department gets 12%, that may mean we can only buy 2 police cars instead of 3 police cars.
Yeah, you guys, I think most of the county people are with the welfare presentations, but you guys all have police chiefs. We have sheriffs and prosecutors. My prosecutor told me, you're not allowed to have an opinion, you're just here to run the numbers. And I responded, you're absolutely correct, and the numbers don't work. You know, if I were to give the prosecutors an average of over 6% raise, I got to lay people off at Public Works. Well, unfortunately, our county engineer is not in that caucus with us. So I'll speak my mind on behalf of everyone in the county and the budget as a whole.
And that's a word that Jerry, that we've suggested that Jerry not use unless he absolutely has to use it. I should phrase,
I can't control myself.
which is the layoff word. So then Jerry uses like pig Latin, a lay off a, you know, Jerry, they understand what you're saying.
RIF,
You know?
reduction in force.
Then he goes with
it doesn't
RIF.
work.
Then he starts citing statutes that deal with layoff. You know, it's just, then he's handing notes to the person next to him, layoff. So again, that's kind of the unspoken word in the room, but I will tell you, I have used it on occasion when I have to. Say, okay, you guys want to be greedy, then you could go back and tell 10 of your guys they're not going to have a job next budget year. That's it. Because we don't have a no layoff clause in our contract, and we have to get the money from somewhere. So this is an interesting one. So you have a contract. You want to change certain things in the contract that you think are absolutely common sense. But the law says the burden always remains on the party who desires to change the status quo. So even if there's a contract provision that is outrageous, it's wacky, right? Don't take it for granted that the arbitrator is going to see it. And also don't take for granted that even if you testify that it's outrageous and wacky, the arbitrator is going to believe you. You need to try to put forth some evidence, some testimony, some documentation as to why that particular provision is wacky. A quick war story, and this is why Jerry hired me in Cumberland County. In Burlington County Corrections Department, many years ago, we were spending between $4 and $6 million in overtime. And it was largely the result of having an 8-hour workday. And as many of you know, you have an 8-hour workday, 24/7 operation, you have to have what? 3 shifts. So we did a thorough analysis and we said, we're going to propose a 12-hour, what they call Pittman schedule. Some of you may be familiar with that, right? So we proposed it to the union, and in fact, we were ready to buy it from the union. And when I say ready to buy it, there was a 2% cap in place. And I said to my clients, the freeholders, I said, look, it's not going to be easy to get the 12-hour workday. We've tried it before under my predecessor, by the way, and the arbitrator turned us down. So it's not going to be easy to get it. We're going to have to buy it. So we actually went in with a proposal that provided for a 2.6% increase per year over the term of the contract. And the union told us, quote unquote, go pound salt. I said, okay, we're going to arbitration. We filed for interest arbitration. And this was the rocket docket that I talked about. It was before Susan Osborne. We put together significant evidence. We did not hire a financial expert. They did. And a guy named Mark Krasson was our financial
He
officer.
is here today. He might be upstairs. Mark, you here?
I can't believe he's not
All right,
here.
he's upstairs.
I was going to give him some credit. But anyway, so we put together a really, really cogent, simple analysis as to how moving to the 12-hour workday will operationally and fiscally help the department. And in fact, it would be better for the corrections officers as a whole. Because at that point, there was only 40% of the corrections officers that had any weekend days off. 60% of the workforce had no weekend days. Under the proposal that we put forth, every single corrections officer would have a three-piece, they call it, Friday, Saturday, Sunday, off every other weekend. Pretty good, right? So contentious arbitration, literally till 11 o'clock at night. I will tell you, between me and the other lawyer, almost fisticuffs. It was not good. But I kept calling him by the wrong name. I think that maybe that did it. But I do that on purpose. Tom knows. And ultimately, the day before Thanksgiving, Susan Osborne, the arbitrator, called me up and said, "What do you think I'm going to do?" Like, that doesn't really happen. I said, "You know, Susan, I think what you're going to do is you're going to give us the 12-hour workday, but you're going to slam us on salaries." Here's what she did. She gave us the 12-hour workday, and the average increase per year was 1.66%. Right? Now, that's why Jerry hired me.
Hey, how could you not hire this guy?
Right? Now, again, it wasn't all me. It was the team. It was the financial people. It was the HR people. We really did it the right way. But the point is that we wanted to alter the status quo, and I knew that it was going to be really hard to do that unless we put everybody to work and pedal to the metal. And we did it, and we were very fortunate that we got the result that we want.
We got the same result with our correction officers, but without going to arbitration. And they were very, very familiar with Carmen's decision in the Burlington County, so they said, "Nah, we're not going to go to arbitration." It worked.
So that was good. So what's happening out there, right? Here's what's happening. Boonton versus PBA Local 212 decided August 14th. By the way, you probably know this already, but all of the arbitrators' decisions are on the PERC website. So you can go on there. These decisions are like 150 pages. So this is what I took out of the 150 pages. But you can go on the PERC website and see what they're doing. So what did the arbitrators say? "I don't award either party's final offers on salaries, but use my own authority to craft a salary based on the evidence and application of the statute." So Brian Kroenig said, "I'm not going to accept either party's salary proposal. I'm going to do it myself," which is exactly what I said before, right? Be careful what you ask for, because he or she doesn't have to choose from one or the other. They can craft their own. What they like, I'm going to tell you now, Jerry hates it. They love split-year raises, right? Like freeze it for 6 months, and then they're going to get 2%, and then we're going to freeze it for 18 months. Jerry's head explodes, right?
You're kicking the
and you can
can
see why,
into the
right?
next budget year.
How about you go down and tell your payroll people, this is how it's going to be, right? But they do that. And that's why I say, try to get a resolution without going to arbitration.
The arbitrator brought it up in mediation back in the back room. I almost jumped over the table. Carmen had a stroke. But
Well, Jerry almost jumped over the table. Jerry then got a medical marijuana card for anxiety, which actually I'm doing
There's
a
a
presentation on that tomorrow if you want to come to Cape May, but that's a whole other thing. Anyway, but here's what the arbitrator awarded in Boonton. 2.25, 2.25, 2.25 plus 1,000 at the top, which actually doesn't sound that crazy in a post 2% cap world, except for, guess what? Went back to the conventional percentage increases over the steps. So the same old stuff, right? The same old stuff that's happening, which is they're going back to the conventional way. Think about the static guide. Think about the static guide, because if you go and propose a conventional guide by increases only, the arbitrator is most likely going to award that.
also think about adding steps.
Correct.
We have I don't know, forget, most of our guides are 15 to 20 years, 18 years, 20 years. That's insane. Nothing's over 8 years. Nothing's over 10 years. I produced, I don't know, I produced 10 guides, and I think 6 or 8 of them were more than 15 years. They will lie to you. You need to find the truth.
West Windsor, in June, same thing. I know it's difficult to read the charts on the right, but the arbitrator Mastriani awarded 2.25, and 2.25. But again, it was percentages over and above the guide, which again, if your bosses, the governing bodies, want to go and say we did a great job because we got 2, 2.5, 2.25, 2.25, they're really not telling the truth.
Then at the budget hearing, try to defend why your police salary and wage has to go up by 6%.
I mean, you have somebody going from 54,000 to I believe 54 to 85 in 4 years. $31,000 in 4 years. It's not bad, right? Any of you making $31,000 more than you were 4 years ago? Probably not, unless you got a big promotion like Tom Rochelle here, right?
Tom's giving up money.
So what else? Irvington case. This is pre-cap. Susan Osborne. Again, see, Susan, she knew she had to stay under the cap. So her award was 2, 1.8, 1.8, 1.7. But what she did was, she actually did the calculation. She's really good at that. She did the calculation as it ended up. It was, those are true numbers. So that's me. I know this has been riveting, but I hope that you've taken some lessons from this.
I know there was at least one question in the middle.
Sir?
there. Can you come up to the microphone?
If you could run, because we only have a minute. Can you run? We only have a minute. Come on.
Yeah.
I'm only kidding.
I want to get your opinion. When you see a guide, we see guides similar to what you showed, where we have a lot of static guides, and the population dictates the fact that it's realistically 6% over the total population increase. Right. When you see an arbitrator make an award like that, is it just because they don't understand the mathematics behind what's happening?
Here's what I'm going to do. I don't want to take a shot at anybody because I don't know who's in this room, except for a few. But I did review what the proposals were of the employer and what the proposals were of the bargaining unit. And the employer's proposals in these cases were percentage increases on top of the guide. So again, from my perspective, the arbitrator's like, okay, if they're okay with percentage increases on top of the guide, it's really a matter of what the number is, right? And particularly what the number is up top. Because once the people top out, it's 2, 2, 2.5, 2.5.
Yeah.
Right?
We were able to get, before the arbitrator came on board, before the mediation, we were able to get an agreement for the static guide. We were at 2.9%, and they came all the way down to about 3.5%. And the arbitrator kept telling us, you're crazy to not accept this. You're crazy. Look at all they're giving you. They're giving a static guide. They're giving you 3 extra steps on the guide. They're giving you the healthcare concessions, on and on and on. And I kept responding, I have a budget to balance, 2.9. The 0.9%, I'm buying those concessions. I've calculated the value of those concessions. That is where we are. So he's trying to push us to get up to the 3.5, 3, whatever it was. We won.
And I would encourage, and many of you are probably in negotiations right now, right? Contracts end in December, many of them. I would encourage you to take a strong look at what I call this static guide concept. It's relatively new. I will tell you, I have been doing it for 6 years now. So when my adversaries say, nobody's doing it, I said, what? But I am.
When you're in the mediation, I forgot I should have mentioned this with the last statement. When you're in the mediation, they're going to come in and tell you how crazy you are and how right the police are and how much, and if they're doing their job right, they're going to the police and telling them how crazy they are, and how management is right and everything else, because it's their job to get a settlement. So they're trying to get you to come up, them to come down. They're trying to get out of there because they get paid the same fee whether they're there for an hour or for a week. But, my team was being very, they were getting very excited that this is what we have to do. And the prosecutor was going nuts that we're going to go to arbitration over this, over that little amount, blah, blah, blah. Not understanding that, yes, it's his job to scare us. He should be scaring them. Let's see where it goes.
So in conclusion, I want to once again congratulate Jerry. I understand that his mantra was GFOA, making the GFOA great again. Jerry, is that true? 'Cause he actually has a hat that says that.
Not in Cumberland County.
Thank you again. If you have any questions, I'll hang around a little bit. Thank you.